B certified evidence was produced for the first time in India. He was also the first person who successfully carried through this historical adjudication case of S. Umashankar versus ICICI Bank through the adjudicator of Tamil Nadu. Not just that, but he has done also in the Cyber Appellate Tribunal, but also the TDSAT and the Madras High Court. He is also a leading HIPAA and ITA 2008 GDPR and also in the Indian Data Protection Compliance Auditor. Sir has extensive senior corporate executive experience behind him. He has been an ex-banker and consultant to several companies in finance. Not just that, he has held top management positions in several companies engaged in the business of banking. Sir is presently focusing on spreading awareness of neuro rights protection and need of law on artificial intelligence in India. Sir is also a well-known netizen activist and is available through the email, which we'll be putting in the chat box. We welcome you, sir. Over to you, sir.
Thank you, madam. I hope I am audible now. I have unmuted myself. Um, can you just confirm how much of time
Yes, sir.
is
Yes.
allocated for this session?
Around 1 hour.
Okay, fine. So good morning, friends. I understand that most of you are legal professionals, but having some special interest in technology related law. I am happy to discuss with you the issues related to data protection law in India, which has been a law which is under discussion for the last several years. And every time we are saying that, okay, we are expecting a new law shortly, but it has been getting postponed from time to time. And hopefully in the month of March, we are going to see a new bill presented in the parliament, which is likely to be also passed. Now, our objective today is to discuss certain issues and concerns related to data protection in India, and also use this opportunity to discuss the new data protection bill, at least the basic contours of that. Now, before we get into the relevant issues and concerns in personal data protection, that is what we are going to look at in greater detail. We need to look at the concept of data protection and privacy protection, then look at the current status and the new data protection bill. Now, when we talk of data protection, first concern to us is the cyber crimes, and the Information Technology Act 2000 has been in place for last 20 plus years, and that has been addressing the issues of concerns related to what we generally call as cyber crimes. But in the recent days, the importance of privacy as a fundamental right and need for protection certain category of data in order to protect this privacy has assumed greater importance. Now, this requires distinguishing personal and non-personal data properly, defining the characteristic called sensitivity of data, and then some discussions we will try to have on the need for protection of mental or neuro privacy and how ITA 2000 can be applied to data protection, and then we will go into the new data protection bill. We will also perhaps address some concerns, or at least flag some concerns related to the new technology developments in artificial intelligence, neuroscience, and things like metaverse. Okay. Now, we are all aware of the importance of privacy as a fundamental right, and the Supreme Court in its August 2017 judgment, which we mostly refer to as Puttaswamy judgment, held that privacy is a fundamental right under Article 21 of the Constitution. Prior to this also we were respecting privacy in the old Karak Singh case and other things, but that was related to some aspects of physical privacy, and the question of the old case of MP Sharma saying that right to privacy is not a fundamental right was clouding our decisions. And fortunately, now the clarity is there that at least for the time being, the privacy is considered as a fundamental right. Subsequently, initially, whenever we look at fundamental right, we normally look at it as an obligation on the government to protect the fundamental right as per constitution for the citizens of a country. But of late, you know that the judiciary is actually spreading its tentacles everywhere. We don't know whether it is for good or bad, but anyway, it is happening. And the Supreme Court has very recently held that the fundamental rights under Article 19 and 21 can also be enforced against persons other than the state or its instrumentalities, in the sense that fundamental rights now become an obligation to the uh, private sector companies as well as other individuals. In fact, immediately after the Puttaswamy judgment, a Kerala High Court judgment in the Woman Chandy case also had made a similar observation that privacy right as held in the Puttaswamy judgment is applicable for the media and private sector. So now protection of the right to privacy of individuals has become a common obligation to every individual beyond the uh, government or its instrumentalities. Now, Puttaswamy judgment highlighted one aspect called information privacy. See, earlier we were talking of spatial privacy or physical privacy, where a person could say that I don't want people to be near me, kind of a thing. In fact, correcting case and other things were mostly like that. The intrusion to the residential premises of a person was the subject matter of that. But subsequently, in other privacy cases, this was extended to information about the family and what is called privacy and other things. So I think this was something which came out of the Rajgopalan case. Now, subsequently, the development of the digitization of the world around us has brought in more concerns about the infringement of privacy because of the digitization of personal data. And this was also highlighted in the Puttaswamy judgment, and they refer to it as information privacy. And in fact, that was considered as one of the prime motivations for bringing in this declaring that privacy is a fundamental right, etc. So we are today looking at information privacy, which is relevant to the digital world. But to understand this information privacy, we need to understand the concepts of data, personal data, as well as the enforceable concept of right to privacy. And this is what we will try to explore. Now, when we use the terms data, it is not something which is very simple, in the sense that defining data is very difficult. ITA 2000 had a definition of data. This definition of data was that data means representation of information, knowledge, facts, concepts, etc., prepared in a formalized manner and is intended to be processed, or is being processed, or has been processed in a computer system. And it said it can be in any form, including computer printouts. So the definition of data in the Information Technology Act closely integrated data with something called the computer. And when a data or a document is printed out of a computer, that was also called data under Information Technology Act, and we can also call it as electronic document for easy understanding the whole system. any electronic document which is processed or being processed or is meant to be processed in a computer is what was called electronic document or data. It could be a message, text, image, or whatever is that. And there was a definition of information also, and it said information includes data. So the definition actually was a circular definition. Data is information, information is data. This was something different in the earlier days when under normal English, we used to make a distinction between data and information, something called raw data, and when it is organized, it becomes information. Nowadays, that kind of a distinction does not seem to be relevant. We use both data and information as some kind of electronic say representation. When we come to computerization and electronic representation, we are talking of binary expressions. So any binary expression can be called as a data. That is, any document or message or any perception which is expressed in zeros and ones is what we call as data, and this is the definition. Now, this definition has also been recognized in a way in the Indian Evidence Act, where it has distinguished oral form of admission from documentary form of admission and electronic form of admission. So section 17 of the Indian Evidence Act recognizes admission in three forms. It has not combined documentary with electronic. It has said admission can be oral or documentary or in electronic form. So in electronic form is a specific form of in which data can be expressed. So we can say data can today exist in oral form, it can exist in print form, it can also exist in electronic form. And most of the time when we are discussing data in the current data protection scenario, we are actually talking of electronic data, because the act itself actually is meant for information privacy protection, not for total privacy protection. Now, because of this, we need to have a technical understanding of what is data. Now, when we talk of a binary data, we are talking of zeros and ones. Now, when the zeros and ones are scattered in some medium, it requires to exist in a medium. That medium is the hard disk or whatever we are trying to take, where certain electronic signals are stored, and those electronic signals represents 0 and 1s. Okay. Now, that electronic representations of zeros and ones, if it is in a chaotic form, that is, it is completely jumbled up and scattered all over it, then that data really doesn't have any meaning to the human being. That is what you can say as no data. See, data in scattered form is no data because humans cannot interpret it. For example, if you take this 0, 1, 1, whatever I have represented here, and would like to read it, it will give something which we can call it as gibberish. Okay, so it has got no meaning. But the same data, if you try to reorganize in some form and then put it through the computer, which you can call as a binary to ASCII converter, these zeros and ones will be shown on a computer screen as DATA with D capital, which is data. So this representation is data, whereas this representation is no meaning. Okay. Similarly, when it is rearranged in a different way, it may say NAAVI. In another form, it can be PDPA. So all these things are binary representations of different sequence of zeros and ones. And depending on the conversion of this into ASCII, it renders some kind of a text data. Now this we call as personal data, this we call sometimes call something as non-personal data, and whether Navi is the personal data or non-personal data itself can be a matter of debate. Now, why do we think that PDPA is a non-personal data, NAAVA is a personal data. It is because of the observer's knowledge that there is somebody who is referred to as Navi. Okay, so it's a nickname of a person. That is a prior knowledge which you have, because of which you read NAAVI as a personal data. And if you are in a company and you are expected to protect the personal data, when you find NAAVI, you classify it as personal data and then say whether I have got a consent or something like that. Whereas if you see PDPA, you don't think it's a personal data, so your approach to protection of that could be different. Now, this is an important thing which you have to remember, that data per se is neither personal nor non-personal. It is all interpreted by the human beings. That is why I have been trying to discuss what I have called as my theory of data, and say data is in the beholder's eyes. We cannot say data lies here in the computer. What lies in the computer is zeros and ones. Now, whether that is data which is personal, non-personal, etc., is in my eyes. So if I am an ordinary person, I am looking at an X-ray sheet. For me, it is only black and white. Some pictures I can look at it. But if a doctor looks at a X-ray sheet, his mind immediately thinks, oh, this is normal, this is abnormal, this person should be having some kind of a disease or something like that. So what becomes a medical data in the hands of a doctor is not a medical data when it is in the hands of an ordinary person. That is why data does not have an absolute meaning or value. It is in the beholder's eyes. This is one of the first hypotheses which I have used. In addition to this, I have used two other hypotheses. One is that data exists in a life cycle which is reversible. So what is raw data today becomes personal data tomorrow, it becomes a sensitive personal data day after tomorrow, then it may be anonymized, it may become non-personal data. So the same sequence of zeros and ones can be jumbled up and can become personal, non-personal, sensitive personal data. That is why we call it as is a dynamic state. And unlike a human life cycle, this data life cycle is reversible. That is, a personal data can become a sensitive personal data can become back personal data, and personal data can become again raw data if it is anonymized. So both ways it can move, and when it changes its avatars, its value also changes. And one of the other hypotheses which I have used is data accumulates value as it transforms from one form to another, and that value should be attributed to the person who caused that change. This is very important for ownership of data. Even in the case of personal data, say data, some part of the personal data is provided by the data subject to an organization. Now, after I get that data, I use my intelligence and my intellectual property and create, let us say, a profile. Now, who wants that profile? Does the profile belong to the data subject, or does it represent my intellectual property? Is a matter which should be debated. Of course, data protection laws today say that this profile also belongs to the data subject, and if you are porting the data, returning the data, or destroying the data, you should destroy the profile also along with the basic data, which may be in some future day actually contested, because I feel that data as presented by the person is one set, data created over that is another aspect. Whether they should be considered as integrated or not is a subject matter of contract. It is like when a person buys a land on lease, or say takes it on lease, say 99 years lease, with permission to construct buildings over it. The contract may say at the end of the lease, the person will return either the bare land as it was given, or along with the construction. These are matters of contract. So in data protection also, these things will be subject to debate. But presently, the development of cyber jurisprudence or data jurisprudence is still in developmental stage. So therefore, sometimes we feel that what GDPR says is law, but actually GDPR is a very inadequate law. We need to actually think and rethink about it. One such aspect is this: whether a profile created out of a basic data presented by the data subject, that right should rest with the creator of that profile, or it should be considered as that of the data subject, can be debated. Of course, the privacy activists may say that no, you have to return it to the, you have to credit it to the data subject, whereas business people may say that it involves my intellectual property. The only place where some compromise has now been agreed upon is when data is being returned. Some laws say that in data portability, only the data provided by the data subject should be returned. The other one need not be returned if it is to be deleted, if it is to be destroyed. So, but that may not be clear in many data protection laws. So this is the nature of data. Technically, it is zeros and ones. In terms of legal perception, it is the perception of the beholder. As I told you, the same data with a person with some knowledge, it may be personal. It may be with no knowledge, it may not be personal. So these are issues which law finds it difficult to interpret. Now, the need for data protection arises basically because data has been found to be having financial value. It is a valuable asset in any business, and companies spend money to acquire data or even generate data, and they also use this data to generate revenue like any other asset. Therefore, it's a valuable asset, and if it is a valuable asset, I have to protect it. Otherwise, I will be poorer if it is misused. So loss or misuse of data belonging to an entity can cause financial loss. In certain respects, it can also cause reputational loss or say disruption to business. So that is why the data owner would like it to be protected. Privacy right is one such right, which we say that is a fundamental right. As a human right, it has to be protected, and therefore privacy has to be protected, personal data has to be protected. You can say that is also a kind of value. So I say that the protection of the value of the data is the basic reason why we talk of data protection. But data protection has got two distinct dimensions. One is the information security area, which is related to protection of non-personal data. Another is the protection of personal data, which is related to privacy protection. Now, privacy is to be protected for an individual for his benefit. The loss, if privacy is not protected, is to the individual, whereas information security or cyber security is meant to protect non-personal data for the benefit of an organization. So the beneficiaries of data protection are different in these two contexts. The beneficiary of non-personal data protection is the company. Beneficiary of personal data protection is the individual. Now, to the extent there are laws which say that if you don't protect the personal data, you will be fined or penalty will be given. Corporates are also interested in protecting the privacy data, and therefore you can say protection of privacy personal data is also in the interest of the company. But basically there is a small distinction when we use the terminology like confidentiality, integrity and availability protection of data. Normally it is applied to non-personal data, but in terms of personal data, apart from the CIA principle, there are other issues which we need to consider. But essentially data privacy or information privacy is a human rights concept and is an extension of right to privacy. I normally try to avoid the use of the word data privacy, though it is a very popularly used terminology in industry, because when I say data privacy, I am more thinking of protecting the inanimate object called a data, and privacy, I look at it as confidentiality. which is also applicable to non-personal data. So data privacy, I personally try to restrict in the use of non-personal data, and information privacy as the terminology which we need to use in the data protection area. But since the market uses these two terms as exchangeable, we can continue to use that as and when required. Now, the concept of privacy in India has developed from the very beginning. In fact, many people say that this concept of privacy has come from outside India, like many other things which we are now discovering as the cultural heritage of India. In fact, Panchatantra and Hitopadesha by Narayana Pandit is supposed to have provided the basic concept of privacy, stating every man is a king in his own house. This is the same thing which the English people called home is the castle. And in Karak Singh case, it was quoted, and many people attributed it to some UK judgment. But in Hitopadesha, we understand that a concept called Sarve Sweswe Gruhe Raja, their own say houses, they are the kings. This is the Hitopadesha made by the Dr. Narayana Pandit.
जो आप उससे कॉमर्शियल करते हैं ना, अलाउ करते हैं, वो नहीं थी उनके पास.
King's children which he was teaching. So this is the very old concept. But of course, India has always given some kind of an extra, you can say, respect to knowledge. So privacy has always yielded to information, dissemination of information. And we have a tradition in our culture that when a person introduces himself to another person, we have, I don't know how many of you are aware, we have something called a pravara, which a person says, I am the son of so-and-so and the grandson of so-and-so, actually is bowing before you, something like that. So the question of privacy was always considered as secondary to information in the Indian context. But anyway, right now, from Rajgopalan case onwards, right to privacy is implicit in the right to life and liberty. That is the jurisprudence we have to follow now. And after the Puttaswamy judgment, it is a fundamental right. But if you ask me whether this Puttaswamy judgment gave a definition of a right to privacy, I must say, unfortunately, the 9-member bench did not give a clear definition of the right to privacy, though Justice Chandrachud did make a mention of right to be left alone. There was Chalmeshwar who said, we don't have to define privacy. We will protect privacy, but we will not define privacy. That is our right to say that we protect something which we don't define. He claimed it as a matter of right of the judiciary to give such gray judgments. But if you look at the detailed judgment, which you may call as obiter dicta or something like that, Chandrachud's judgment uses the term right to be left alone or let alone as the concept of privacy. But this right to be left alone is actually a state of mind of an individual. You cannot say that a person is feels left alone if he is isolated, or he does not feel left alone when he is in a crowd. Both are possible. And also this feeling of right to be left alone can change from individual to individual. It can change from same individual from time to time. We thinking that we can make a law for protecting how an individual will express his state of mind is something which is a challenge in the legislation of privacy. That is why the impossibility of protecting the state of the mind has made it necessary for us to redefine the right to privacy as a right of choice of the individual, and it is left to him to say that at this point of time my right of choice I exercise and say that this is my current preference, that how my personal information can be used, and that becomes the direction to the persons who are having that information, and that is what is getting protected. So in the current state, what we are looking at as privacy is basically data related privacy, because of the importance of the digital life of the individual, and the protection what we are looking at is that protecting privacy of an individual by following certain measures related to processing of personal data. That is, whether personal data can be collected, and if it is collected, how long I can keep, how can I process. Those are the things which constitute what we call as data protection. In Karak case, it was the person's choice to not allow a third party to enter his house during certain hours or something like that. Here it is how my personal data is being shared with somebody else and how that shared data can be used. That is the essence of the protection, and it is a technology concept now. It is from human rights concept, it has moved to be a technology concept, and we talk of technical controls, written policies, and enforcement or governance system. That is the data privacy which we are talking of today. So if you want to give a definition, something like this should be tried. That is, right to privacy means right of self-determination and enforcement of a natural person. This is right of a natural person on how the personal data may be shared and used by a recipient. So this is how we have to understand the operating definition of privacy as of now, and the concept of data protection therefore needs to be looked at in this context. And if you look at digital data, which is both personal data and non-personal data, the earlier law, Information Technology Act, actually protected both personal data and non-personal data. And now we are trying to create a separate law called Digital Personal Data Protection Bill or Act, which will try to protect personal data, which means that non-personal data will continue to be protected by ITA 2000. In fact, ITA 2000 is being bifurcated, and it will continue to have some aspect of protection of all kinds of data, personal and non-personal, but certain aspects of personal data regulation is moving over to the new law. In future, both these laws will be in existence. Now, to understand this DPDPB 2022, we need to actually look at several aspects, one of which is distinguishing the personal and non-personal data, without which we do not know which law to apply. So basically, personal data is considered as data about an individual. That is, if some data can be used to identify to whom it belongs to, you can call that as personal data. Now, how do we identify it with a particular person? I told you about, so let's say I've got a health report, a blood report or something, blood group so and so, or cholesterol so and so, or something like that. Now that is data. Now it becomes personal data when there is a headline that this is a blood report of so and so. So the name becomes an identifier which converts data into personal data. Likewise, there can be many other kinds of identifiers like your mobile number, PAN number, or Aadhaar number, or maybe your address, physical address, email address, etc. So these are all called identifiers. Now, identifiers is one category. Identifiable data is another. When an data is associated with an identifier, it becomes an identifiable data, and that identity of a person, if it is available, we call that as the personal data. So that is how personal data has to be identified. And we actually debate whether identifier alone, when does it become a personal data? For example, if I simply say navi@gmail.com or something like that, is it an identifier? Now, there may or may not be one single person called Navi in the whole world. So you cannot distinguish even a name. If you take, if you say Vijay Shankar, how many Vijay Shankars could be there all over the world? It doesn't mean that it always should mean me. So Vijay Shankar is not yet identifiable information in its fullest sense, which means that it is not personal data. It is one of the identifiers. But when you combine that identifier with another identifier, say address or some profession or say mobile number, then you are increasing the identifiable nature of the identifier, and then data progressively becomes personal and more personal, you can say. That is why we say that personal data has to be recognized as a set, not one single thing. Name alone is not a personal data. Email alone is not a personal data. There are certain unique identifiers like your Aadhaar and other things which are reasonably unique in the sense that there can be only one person in India with an Aadhaar number of a particular thing. Biometrics is also one such thing. So they are unique identifiers. So you have to make a distinction between unique identifiers and other general identifiers, and in combination a set of data becomes personal. This is how an input of data to a company may come as non-personal data, but when it is combined with some other data within the company, it may become personal data. So this is where a company suddenly finds that data, personal data gets generated within its say fold. That is, when it came in, it was not personal data, and I separately got some other information, and as a company I have got set A and set B, and since I am the common owner of both set A and B, when I put them together, I now can identify the person, therefore it becomes personal data. So set A was not personal data, set B was not personal data, but A and B together is personal data, and that happened because I, as a company which is a juridical entity, has a control over both set A and set B. This is what we call as discovery of personal data within an organizational setup, which is a very tough process in its say protection obligation. Now we say that you have to protect personal data in a particular manner, but I never knew that set A was a personal data, so I did not protect it. I never knew that set B was a personal data, so I did not protect it the way data protection law says. But now I can argue that since both set A and set B were with a single person, they together constituted personal data, and the company has the obligation of personal data protection compliance. And that is how the compliance obligations of different data protection requirements starts with the discovery of personal data, classification of personal data, first of all into personal and non-personal, and later on personal and sensitive personal, critical personal, and so on. So these are some of the important techno-legal issues of distinguishing the personal data from other data, and how the anonymization, de-identification, pseudonymization applies. Sometimes we do not know how to treat personal data of deceased persons, whether the data protection law applies only to living individual. These are all issues which is still debatable. Our law talks about nomination of data ownership. Now, nomination can be there only if you also recognize ownership of data, because nomination essentially means that you are trying to transfer the data rights even after death, which of course Information Technology Act does not permit an electronic document to be created for passing on the estate. But you can have a physical will to transfer a digital asset on death. So nomination is possible, but the nomination instrument has to be a physical instrument, not an electronic instrument, at least as of now in India, unless ITA 2000 is modified. Then there are issues like the email address. Now, email address at company's name. Now, is it a personal ID or is it a business ID? If it is a business ID, should we consider it as non-personal data? These are issues which are things which need to be decided in law. Then minors data, then proprietary data. Now, if you have got a proprietary concern, it is a non-business, it's a business entity. So information about a proprietary concern or a partnership firm should be considered as non-personal data. But if the name of the company is Mehta and Mehta, something like that, and Mehta is the proprietor or say partner, one can argue that whatever you say about Mehta and Mehta as a partnership firm, you are also talking about Mehta the individual. If you say the proprietor of Mehta company is in railway station today, you are actually saying Mr. Mehta is in railway station. So whether that information should be considered as personal or non-personal is a matter of debate. Now, GDPR has not sorted out many of these kind of distinctions, and that is why in India, my recommendation to the government was that some of these things need to be clarified. And those of you who are interested, please visit my website navi.org, where I had carried several articles under the series Shape of Things to Come. That was before the government came up with the draft. I tried to pour out all my ideas on what should an ideal data protection law can be. So some 16, 17 articles are there. Some of these things I had tried to discuss there and suggest that we should try to provide this clarity which GDPR has failed to give. Now, of course, DPDPB is there, but it has not provided all the details. It may do so in the next set of rules and regulations. Similarly, defining sensitivity of data is also an issue. Whether you should call something sensitive based on the harm caused to the data principal or harm caused to the data organization is something which we need to debate. In terms of privacy, obviously the data principal is the focus of attention. In information security, it is the focus is organization. So sensitivity may differ depending upon that, and within that, whether the harm is critical or sensitive, whether health data is sensitive, financial data is sensitive. These are all things of detail which we need to determine. Again, if you look at the concept that data is in the beholder size, sensitivity of data is also in the beholder size, not in the data. So you cannot say this data is sensitive because it is so and so. Now, if you give me some medical terminology and something like that and say some intelligible word, a doctor may know what it is, I may not know. So in my eyes, that is not sensitive, whereas in his eyes it may be sensitive. So the data sensitivity is also a factor of who is looking at the data. If you remember, in Information Technology Act as well as in IPC, when we discuss about obscenity, obscenity is in the beholder size. So something is obscene when it is presented to, let us say, a minor. The same information when it is presented to adults, it may not be obscene. If it is presented to a doctor community, definitely it is much more a kind of a professional information. So this concept of the data to be interpreted based on the recipient is already there in our law, and that will continue to be used in the data protection law. Now, Information Technology Act 2000 itself is the current data protection law in India. This we should never forget. Whether personal or non-personal, if a wrongful loss is caused, that is covered under Information Technology Act. And there is also an adjudicator, appellate tribunal, high court, Supreme Court. There is civil penalties, there is criminal consequences, there are law enforcement responsibilities, CERT-In is there, controller of certifying authorities is there. So a lot of things of data protection is there in Information Technology Act. 43 capital A has something called reasonable security practices. 72A has contractual conformity requirements. 67C has got the data retention norms. So whatever you expect in a data protection law is already there in Information Technology Act. In fact, there is also a concept of due diligence under Information Technology Act, and due diligence is the best practice, and best practice can be derived from the environment. And if the government has brought in a bill called DPDPB 2022 and released it for public comments, the following the measures mentioned there becomes a due diligence under Information Technology Act. That is why I say data protection law is already in India. We don't have to wait for DPDPB 2022 to be passed, but right now it is in a draft with about 30 sections spread over 6 chapters, a very simplified version of the bill compared to GDPR or our own earlier version. The essence of the new bill is that it addresses the digital personal data protection. It declares that this is meant for digital personal data protection. I am not covering privacy protection. Don't expect this to be a privacy protection in all its sense. It is only a digital personal data protection law, and it is kept very simple. But of course, some details will come through the subordinate legislation, the notes, rules and regulations, and the law itself makes a specific mention in its section itself, section 3, which says provisions of this act shall be read as including a reference to rules made under this act, so that nobody can question that subordinate regulation cannot override this regulation. By adding the section 3, what they have done is they have merged the subordinate regulation with this main regulation. And while this can always be questioned by constitutional experts, I think that what they have done is they have extended the meaning of the provision in regulations and brought it into the main law, so that they have the same force. In fact, recently we had a discussion in GDPR that the EDPB, which is the enforcement authority, had interpreted the GDPR in such a manner that you can call it as ultra vires the GDPR. But EDPB has issued that guideline. So similarly, there could be discussions in India whether the Data Protection Board will come up with regulations which are ultra vires the main act, but that is for the future for us to discuss. But basically, this law will be applicable for digital personal data, which is personal data collected online, as well as personal data collected offline and later on if it is digitized. Basically, it is applicable to activities in India, but if digital personal data is being processed outside the territory of India, it is also covered under this act to the extent that if it is related to the activity in India. This is, of course, the common extraterritorial jurisdiction which such laws are maintained. It is not applicable for non-automated processing, offline processing, and then processing for personal data. There is also a mention that it is not applicable for personal data in existence for over 100 years. Now it uses the term data principal, who is the individual whose personal data is the subject matter. And in the case of a minor, it says data principal includes the parent, which means that the personal information of the parent or the natural guardian is integrated to the child information. They are not two separate things. This is something which requires further discussion on a later day on the legal implications. Personal data is, of course, data about an individual. Now, government has placed a lot of flexibility into the act so that exemptions can be given to BPOs, startups through separate notification, and exemptions can be specific to certain aspects like notice or obligations or something related to rights. But normally, security is not exempted. It is available everywhere. And as in any other data protection law, there is a need for a proper notice and obtaining of the consent, which has to be free consent by affirmative action. Now, consent, of course, is withdrawable, there is also a recognition of deemed consent. Of course, when you think that consent is a contract, deemed consent automatically becomes available under Indian law. But here it is specifically mentioned with a heading deemed consent. It is available in employment scenario, public interest scenario, law enforcement scenario, health emergency, judicial requirement, disaster, and public interest. And public interest actually is defined as to include several other things like information security, fraud, debt recovery, and so on, and processing of publicly available personal data. So consent is required, but deemed consent is presumed in certain areas. That is how the exemption of consent is provided. In the earlier law, we used to have a separate chapter on where consent is exempted. Here it just comes under one section on deemed consent. Harm is defined again in a very simple form. It uses the terminology any bodily harm, and whether this bodily harm includes mental harm and the neuro rights which I am talking of is again a matter which will go into a discussion later on. But we feel that if free consent, if we talk of free consent, if you talk of right of choice, then you must recognize that the current developments of neurotechnology means that what goes on inside the mind of a human being can be modified with an external, say, computer input. It can come in the form of a sound. Of course, if somebody is having a chip inside the brain, or say is wearing a electrode helmet, then directly the computer information goes into the person's brain. And people say that even sound waves of a particular frequency, if it is provided to the individual, that also may change his thinking. So therefore, the concept of free consent, the concept of right of choice does not have a meaning unless you consider the neuro rights as a possible or necessary extension of privacy rights. Similarly, the artificial intelligence developments of today change the meaning of automated processing, and therefore we need to have artificial intelligence regulation along with neuro rights regulation as extension of the privacy rights. It may start with the imposition of ethics, but then later on it has to come as a specific law. So DPB 2022 may be only the beginning. You may have more additional laws which need to come in. The stakeholders which this law recognizes is the data fiduciary, who will be responsible for compliance, data processor who assists the data fiduciary, and a person called data protection officer who takes responsibility within the organization, and a data auditor who is an external person who examines a company's compliance. And data protection officer and data auditor are the new, you can say, professional employment opportunities which come up. Lawyers may bid for that. Technology people also may compete there because that requires basically a combination of technology law, technology information knowledge, and law knowledge. There is also another role considered as consent manager, who acts as an agent in between the data principal and the data fiduciaries. Consent manager is also a data fiduciary, but his basic approach is he's like a trusted person for the data principals. He is not an agent of a company. He is the agent of an individual. So that is a new role which has been assigned in Indian law. It is not there in GDPR. Obligations are mentioned for data fiduciary. Basically, there are something called data principles. That is, obtain a consent, maintain data accuracy, make the collection purpose oriented, keep only minimal information. All these things are the obligations of the organization. And in certain cases where somebody is considered a significant data fiduciary, there are, of course, additional responsibilities like appointing of a DPO, using the independent data auditors, conducting what we call as data protection impact assessment, and so on. Who is a significant data fiduciary? The government may decide based on the type of data which is being processed, volume of data which is being processed, and the type of data or the impact could be even risk to electoral democracy, security of state, public order, potential impact on the sovereignty and integrity. These are the considerations under which an organization can be declared as a significant data fiduciary beyond the volume and sensitivity of personal information. Apart from the rights, which are normally the right to information, right to correction, and the data principle is provided a right to grievance redressal, which is unique in India. And then there is also this right to nominate. Additionally, this law expects the data principle to also take some duty. And if the person is not following that duty, he may even be punished with a small penalty or something like that. And in terms of cross-border transfer, there is a new thought which is coming up, which is that the government is going to have something like a mutual assistance treaty kind of a thing, country to country arrangement, with which transfers of personal data would be provided. And some very innovative thoughts are being explored by the government in making the cross-border transfer much more friendly than the GDPR. GDPR is something which is not practically implementable in many countries, whereas Indian law, what we are thinking of now, is going to be perhaps an example to the whole world. Now, exemptions are provided for various things, including the government, including the law enforcement agency, etc. And one of the things which the government has thought of is they can create an instrumentality of the state in the interest of sovereignty and integrity, and such an entity. What we mean by instrumentality, we will discuss details sometime later. But if it is considered as a document or a separate entity, they will be exempt from the certain provisions. Maybe the ED will be exempt, maybe the IT, NIA will be exempt. So those are the ways exemptions will be provided. Now, as lawyers, you will be also interested, what will be the regulatory agency? Government is presently thinking of a data protection board with a chief executive who will be government appointed. And this data protection board will be a digital organization. That is a very important concept. The strength composition will be decided, but essentially chief executive will be appointed by the government. No more discussions on the appointment committee. Penalties are up to maximum of 500 crores. There are different provisions. And this is how the DPDPB 2022 is presently being thought of. To summarize, it's a truncated bill. It is dependent on subordinate legislation. Some controversial provisions of the earlier versions have been completely avoided, but they may resurface when the notifications are given. It addresses only digital personal data. Rights are curtailed to with no right to portability, and right to forget also may not be there. Sandbox system kind of a thing may not be directly available, but it may come in rules. Algorithmic transparency is not presently mandated, but it may come through rules. DTS system, data trust score, which was there in the earlier thing, is not presently mandated. Details of DPO requirements, data audit requirements will again have to be indicated. Something like codes of practice, which was there earlier, is also not there now, but it may also come back. This is a quick review of the whole scenario as of now. And in case any time is left, any questions are there, I would like to answer that.
So am I audible?
Yeah.
Okay. Thank you so much, sir. It was quite an enlightening session. Also, the students have visited your website, and the all section is towards the cross-border transactions, which you have just right now mentioned. So there are a few questions. If you permit me, I'll ask.
Yeah, please be slightly louder. Okay. Yeah.
Yes, sir.
Yeah.
So there's a question asked by Ravindra sir that the IT Act focuses on the digital transactions or related protection in all sections where data is in question. However, the latest bill just focus on digital personal data.
Yeah.
What is your comment on it, sir?
No, earlier, whatever was thought of was protection of all the kinds of data. Now we are, that also
Usually
has section
HPCR.
43 capital A. Now, say, what was there in section 43 capital A is being translated into a complete set of law under this DPDPB. So you can say the two will work together. So it is not that because you have got DPDPB or the protection of personal data, you don't have to protect non-personal data. It is not like that. That will remain, this will remain. The only problem you have to sort out is whether there is any overlapping of the provisions between the ITA 2000 and this. There, the certain director and the data protection board will have to actually work together. That's all. They should not start fighting with each other. But basically what may happen is any disputes relating to personal data will be handled by this data protection board, and non-personal data related issues will continue to be handled by CERT-IN. So I think if there is no conflict, they will have to work together.
Okay. So the another question is that do we have a regular or ongoing data audit process set up for the future?
Yes, actually, companies like ours, like our NGOs like FDPPI has already introduced a data audit system. We have got our own frameworks. We don't depend upon an ISO framework created by a foreign organization. Royalty has to be given by the country. We have got indigenous, say, framework which is focused on compliance of Indian law, and that can be used even now. And when this act comes, there will be something like a concurrent audit which the companies will have to do so that they are compliant on an ongoing basis. That part of that will be done by internal audit team, but at least once in a year an external auditor will have to check that, and I think that will be the process which will be there. So there will be audit, it's already there, and perhaps market has to accept the framework which we have called as PDPSI, Personal Data Protection Standard of India, which is actually better than any of the ISOs and other things, but it will take its own time to get market acceptance. So such frameworks will be there, and also perhaps there will be other frameworks which the ISO standards also will come up with subsequently.
So lastly, I have a question. Let's say you have mentioned about data accumulates value as it transforms from one form to another. Also, you said that the value of data belongs to the person who created the given state of the data. So my question is regarding the security, that do we have a way to monitor and detect the security incidents continuously?
It is definitely, I think the companies are equipped to do that. Say, for example, if data is now non-personal data, now you have some kind of protection given to that. Now, when it becomes personal data, your system has to recognize that change of avatar, and correspondingly, the security required for personal data has to kick in. Now, when this personal data becomes sensitive personal data, so it has to be recognized. That is the status or classification of the data as it changes its avatar within the organization needs to be discovered by the company, and accordingly the security norm has to be tagged. Like if I have, for example, I say all critical data will be stored only in encrypted form is a norm which I am having. Now some data which was not critical yesterday becomes critical today. Then suddenly this encryption should apply to that. This is the system which they have to do. You can call that as compliance by design or privacy by design, security by design. You must have that. This is for technology people. Technology people should have a architecture to identify what type of data is present, and to that what is the relevant form of security to be applied. It is possible, but they have to put their heads together. Law people will have to provide assistance to the technology people so that they understand what is a personal data, what is a sensitive personal data. The IT person may not understand that. That is why the knowledge of data protection law is essential for the technology people also. Otherwise, you should build up the team. The DPO is the person who has to head that team of technology and legal persons, so that the question which you are asking can be addressed in terms of technology. If I am a law person, I may not know how to create a code for this, but I will definitely say that this has now become sensitive personal data. Please do encryption or push it to the encryption store. That much I can say as a law person. Now the technology person has to actually initiate that through the coding of the process. So that is where the two people have to work together, and then it is possible to change the security as required.
Okay. Thank you, sir. Now I call Girish sir for vote of thanks. Over to you, sir.
Uh, good morning, sir. Am I audible?
Yes.
Rudrakshi, yeah. On behalf of Postgraduate Teaching Department of Law, RTM Nagpur University, as well as on behalf of all the students and participants gathered over here, uh, I would like to express my deep sense of gratitude for enlightening us through the journey of data protection regime in India, exploring us, giving us an exploration that what are the challenges that are faced, what is the concerns that are growing in, how the data can be, its lineage can be determined through the Parva system, what are the probable provisions of DPDPP, or there may be some new challenges coming up in the future. How earlier provisions are can reappear in the DPDPB. So I really want to express my thanks for increasing our level of awareness about the new field and developing rather more important field of future revolution about the personal data protection. Since privacy is now guaranteed as a fundamental right and information being the unalienable, unseparable part of privacy of an individual, privacy which is also required at individual level and at institutional level, the security is required. So both the things, how the law is trying to be cope up with the changing demands of the technological sector, that is being explained to us by Navi sir. Once again, on behalf of the department and on behalf of all the participants, I formally express thanks and appreciation towards Navi sir for sharing his valuable expertise and experience with us. I also express the thanks to the organizer of this webinar who has taken efforts for organizing, making the forms and technical assistance, the team that is continuously providing us the technical assistance without whom we could not have completed or started the webinar at first place. And my thanks to the head of the PG Department of Law, Dr. Payal Thaure ma'am, who has given us an opportunity to gain the information and the knowledge in such a relevant field of law. Thank you, one and all the participants here. Again, thanks, Navi sir, and thank you all the organizers team and the participants. Dhanyavad.
Thank you.
Thank you, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you so much.
Thank you so much, sir.
Sir,
I
this
request
recording will be
students.
available on our department's YouTube channel. We will share the link with you as well.